what I'd like to talk about is just cover the aims and objectives for today in this webinar. So we have the first aim of this is to increase understanding of employment laws and help managers discipline in line with legislation. The objectives for today is to discuss an overview of employee rights relating to a fair dismissal process, to highlight the risks of not conducting a full and fair investigation, and to explore how our Code Total HR provides useful policies and template letters to help practices comply with their legal obligations. So there's quite a lot to cover, I know, in an hour. And the learning outcomes, what we're looking to achieve is to avoid potentially costly mistakes when implementing the disciplinary process and to improve your understanding of the ACAS Code of Practice relating to disciplinary procedures. And also to cover an understanding of statutory employment rights relating to the disciplinary process as well. So I'm just going to talk about the session content. I'm conscious that it's all your lunch hours, and a few of you having lunch at the moment as well. We're going to cover in this section an overview of the disciplinary procedure. We're going to talk about why it's important to have that in place. It's a useful tool. When to implement formal measures, and this is quite a common question that we get asked the helpline of when to use the actual process, and we're talking about that, and what a fair dismissal process actually is, and on all the risks at each stage of those processes as well. We will touch on unfair dismissal claims as well, and I'll go through that and some of the common mistakes that we speak to our members about and obviously help them resolve before it leads to that. We will also show you some useful policies and templates. And I'm going to end the seminar with a summary of do's and don'ts regarding the disciplinary process, just a summing up there. So if I could just move over to the next disciplinary procedure. So why have a procedure in place? Why do you need a disciplinary procedure? So it is about that framework, and it's important that we have this in place to know how to manage your team members and where everybody stands and what the consequences might be. Now, the actual disciplinary procedure needs to be in line with the ACAS Code of Practice. Now, those of you probably know about ACAS and have come across ACAS, but may not have actually read this document. And we do actually have this on iComply as well. It isn't a long document. It's only about 10 pages, and it's a framework again. It's not too detailed. It just gives a guidance of what you must follow as a fair dismissal process. However, it is a statutory document, and it is taken into account at tribunals and claims if you don't follow this. So it's really important that you're aware of it, and all our procedures are in line with that. What we want to avoid really is having a culture of disciplinaries in the practice. They are time consuming. If you think the average disciplinary could be anything to a month to 2 months to resolve, sometimes longer in gross misconduct situations. So it's incredibly time consuming and costly and draining on the employer who's dealing with it and the employees. So we want to look at prevention, and that it's our sort of tagline in the HR is better than cure. So preventing things is really, instead of a first offence, a first demeanour, for example, an employee who is coming in late, rather than hit them with a disciplinary straight away, it's not there as a stick to beat them with, it's there to correct behaviour. So we encourage that you have those informal discussions first, that you meet with the employee, you spell out to them what's expected from them, and you put down an action plan of improvement. Now, the ACAS no longer recognise verbal warning stages, so you won't see this in any of our updated policies. It's not there anymore. Some people still have it. However, what we do recommend is you meet with them and have a note on their file about any behaviour that you've got concerns about. And there is opportunities for them to improve and support, and you have those records there. If there is a situation when they haven't improved, that you might end up in a disciplinary situation, and that would form part of your investigation as well. So if we look at when we actually have to implement formal procedures, now the disciplinary procedure itself is therefore mainly dealing with conduct issues, which I'm going to break down in a moment between misconduct and gross misconduct. It's also used for capability. You would normally have a separate policy to deal with this, as it's much more sensitive, but it is seen as one of the fair dismissal reasons for an employer can dismiss on grounds of capability. This is linked to performance. Also, quite often it can be dealt with where you have an employee who's on long-term sickness, has severe health issues, is not able to do their job, or they have lost a qualification that they need for the role. So we're not going to cover capability today. That might come into one of our later webinars. We're going to look at conduct. Okay, so let's start with misconduct. When we think about this, it could be minor breaches, and we speak to our members, the most common, I think, that comes up regularly when on the HR line is reasons for lateness. Quite often, poor timekeeping would be a common one that, that employers are having to deal with. Again, unauthorised absence from work is there as well. And minor breaches, I'd say in the practice environment, this would come under not following your infection prevention, your control procedures, that would be a breach. And also dress code is a big one, not wearing those appropriately. We get a lot of calls about those issues. Using the mobile phone in the practice, that also comes under this umbrella. So these are the types of breaches. When we say unauthorised absence, it could be that they haven't followed the absence reporting procedure. And this would seem as a breach of their contract as well as a minor misconduct issue. Quite often you would be talking to them about these first, and there'd be several warnings and discussions, informal chats about what you'd expect from them and how to improve before you've got into a formal disciplinary situation. So gross misconduct. Now, to define what gross misconduct actually is, it's where the employee has perhaps committed something that is so serious and has damaged the relationship permanently with the employer and has broken that trust and relationship that they simply cannot tolerate having them there in the practice any longer. So unfortunately, on the helpline, we have seen an increase. We've had a number of situations lately where we've helped our members with dealing with theft and fraud situations. And this can be anything from perhaps stealing from petty cash, that's quite a common one, unfortunately, through to something more serious, a gross misconduct of fraud situation there. And both of those, it could be £10 from petty cash or taking thousands, they'd both be deemed as theft and would come under this umbrella. Also bullying and harassment in the workplace, and the one we have seen really increase in call at the moment has been sexual harassment in the workplace. Now this is probably because it's so prevalent in the news at the moment, and we've seen an increase, and I think employers are becoming more aware of it and wanting to deal with it, so we're getting a lot of calls on that one, helping our members through those situations. But also, you may have come across this, hopefully not, but we have had situations where employees have lied about their qualifications, their GDC registration. Unfortunately, that does come up quite often, they found that is not a genuine number or registration, and forged documents. This could be a DBS, for example. Now, I had to bring in GDPR at some point in the presentation, so this would come under if there's a serious data breach. And this could be where you have an employee who has breached and shared special category data, for example, and it has resulted in bringing disrepute to your practice as well. Alcohol and drugs on the premises are very serious no-no, so that would come under gross misconduct, as would physical violence and any racist language as well. So when we start with a disciplinary process, now I wanted to really summarise what the actual steps are, because at every stage of the process, unfortunately, there is a risk involved. And if you get any of these wrong or miss any of these out, it results in an automatically unfair dismissal process. So I can understand by the numbers that we have attending today, I can see members are fully aware that this is a tricky subject and that the risk that they're aware there are lots of risks involved, which is why you're here. So if we start with the allegation suspicion, so we think of a scenario that, and again, this is a common one. We have a team member that said to you that their colleague who was off on the Monday was not genuinely sick, that they were seen out, say, partying on the Sunday night, and actually posted this on social media. And this is an employee you've already had several conversations with about their attendance and concerns. So you now have an allegation of suspicion. The next step is an investigation, then an invitation to a disciplinary hearing, the hearing itself, and then the outcome. And when we're talking about outcomes, this relates to the type of warning that you give them. And it could be an outcome that it's actually a training need, or this counselling, or something else completely different. It doesn't always have to be a warning. It's either a first written warning, second written warning, which is final, and then it could be through to dismissal. And then there's the appeal stage. When we look at common mistakes later in the slides, a number of these are quite common that get missed out. So we're going to cover those. So the disciplinary investigation, so going back to the scenario of the employee that you suspect was not actually genuinely sick on the Monday. So think about who can actually conduct the investigation. I would say the investigation is the most important stage of the whole disciplinary process. This is what you're going to be referring to in your disciplinary hearing. It's a key bit of information that you need, and it needs to be done well and thorough. Now, we know when we speak to members that you're limited of who resources that you have available to be able to carry out the different stages of the disciplinary process, which is why we quite often advise on how to conduct an investigation and the types of questions to ask. Quite often it's the practice manager who's also been involved in all the informal discussions and those stages of trying to improve things, who's now having to carry out the investigation themselves. And this is all in the preparation though, is to first of all start with making your list. We have a template on iComply that is a record for your investigation. I'd strongly recommend using this to help with that. But it's all about fact finding. What you're trying to do is find out evidence not only supports the allegation, but also shows that it may not be true. So you're looking for evidence for both sides. So in the preparation with this situation, you'd be making a list of who do I need to speak to. So the employee who actually raised the allegation in the first place and brought your attention to it, you'd need them as a witness and ask for a statement from them. Ideally, you would ask them to sign and date that statement. However, some people like to remain anonymous, and that's fine. You can do that. Physical evidence. This is such an important part of the investigation, and it can come in all forms. The first place to go is the employee's file. You would go back through there to see what previous warnings they may have had, informal discussions. Do they already have a final warning on their file? All of these things that are in place. Also their training records. This can tell you so many things about the employee, of what they have done or haven't done, or if they're saying they weren't aware of what the absence reporting situation was, for example, you have evidence there that you've trained them on this. This brings me into the actual investigation meeting itself with the employee. What you need to do is ask some open-ended questions. Make sure that it's not just yes or no answers that they can give you. So in this situation, you would be saying to the employee, can you explain to me, can you tell me what the actual process is for calling in when you're not well? And you'd ask them to explain that rather than saying, do you know what the absence reporting procedure is, which would just result in a yes. So you're testing their knowledge. You want them to show their knowledge, which will then be talked to and expressed in that investigation meeting as well, which you'll use in the hearing. Think about time and attendance records, other physical evidence, cameras, CCTV, if you're able to use that, that can also come in. But also quite often that comes into this evidence is social media. So Facebook postings quite often are there and they're public, and you can actually take screenshots of this to show actually you weren't in work today, but it says you were out here shopping. So there's lots of things that there you need to think about. But ideally, they should be reasonable, adequate, fair and neutral. And that's words taken from the ACAS code. And it's, again, very difficult when you're very closely involved and at each stage as well. So we understand how difficult that is to take a step back. But in this scenario, I would also look at potentially why the employee who raised the issue, is there any beef there? Is there any history there? Would it be a vindictive thing? So you are looking for evidence there as well. Okay, so suspension. This is a tricky one, and we have been fortunate with our members that when we speak to them, we've been able to step in and prevent this happening too quickly. So when you have a gross misconduct situation, you have to have a very strong belief, a genuine belief that they have committed such a gross misconduct act to be able to suspend. It shouldn't be taken lightly. It really is a last resort. And also, if you suspend too quickly and then you find out there wasn't anything that's happened there and it didn't warrant that level of sanction, you could be exposed to then that employee either resigning because of it or ruining that relationship with them. So when you suspend, you also need to think about how you suspend, to not march that person obviously through the practice, to do it privately, because it doesn't mean they're guilty. It just means that you're not able to have them in the practice physically while you carry out the investigation. Now, it does mean if you need to get access to their computer and things like that, you simply can't have them there. Or if they're not safe, particularly where it comes under a physical situation, then you would need to suspend them. The important thing is you confirm the suspension in writing. Unfortunately, this is where we do see some of our members have fallen down, and we've tried to support them, obviously, at damage limitation stage. So you need to get advice first before you're considering this. And you confirm that they're suspended, and you need to state in there the duration, how long you anticipate they'll be suspended for, and put that in writing to them. They should be on full pay and benefits during the suspension, and you need to tell them who they need to contact as well. So if you don't state that or don't pay them, which I know is a common error, you could be exposed to an unlawful deduction for wages for that. Okay, so the next step is the invitation to disciplinary hearing. So if we go back to the scenario of the employee who we suspect was not generally sick and was taking unauthorised absence, you'd be writing to her now. You've done your investigation. You feel there is enough evidence there to invite and take formal action. So you need to write to her. Now, we do have template letters on our iComply that help you with this. However, with the Total HR, we will write and prepare these for you. So it's really important you have the key information. So that information needs to state when the hearing is, where, all of the general information about the date, time and venue, but also the things that need to be in there, otherwise it's automatically unfair, is the allegation themselves, and it can be more than one allegation if you're covering that. So it could be unauthorised absence, for example, but also failure to follow the absence reporting procedure. There might be 2 allegations. You need to include the investigation notes and all of the physical evidence, everything you're going to be referring to and that you've covered already. They need to have full sight of this to make it a fair process. You also need to state what the possible outcome is. This is so important. If you, so for example, if they are facing a termination, it needs to state that one of the outcomes of the hearing could be termination of your employment. However, no decision can be made until after the hearing. It needs to cover that they have the right to be accompanied, which will be with a work colleague or trade union representative. And I'm going to talk a bit more about the role of the companion in a moment. Okay. So the right to be accompanied, and unfortunately this is an area where all employers, not just dental practices, that slip up on. So the statutory right, legal right that an employee has is to be accompanied by a work colleague or a trade union representative. Now you can ask to see the credentials before the trade union representative attends. You're allowed to do all of that, that's fine. But where employers do slip up is if they say no to other alternatives. Now, it's important if you, say, for example, have a younger team member who asks if she can be accompanied by a friend or a parent, that you consider this. It's not an outright no. It is difficult when they want to bring parents in, and this is actually quite a common one. However, because they're so personally involved, but you do need to show you've considered it. Quite often, it can be a translator that they want to bring in, and it's really important that you allow that if they're asking for that, because again, it would be seen as an unfair dismissal if they haven't fully understood and been able to communicate in the hearing. Now, the other side of it is the actual role of the companion. Now, what can they and can't they do in the actual hearing? It can be quite intimidating to have a trade union representative there. From my own experience, they're experienced, they attend these quite often. So be prepared, don't feel rushed in the hearing. What they can do, they can ask questions, they can ask for clarification, they can give their opinion and talk about things, they can confer with the employee, they can adjourn the meeting. What they can't do is answer any questions that have been directed to the employee, so they can't speak on their behalf. Now, I will say there was a case not that long ago of a dental practice who the practice manager was facing, I think it was only her first written warning stage, never been in any issues before. And she had actually asked if she could bring an alternative to a colleague and trade union representative. She asked if she could bring the previous practice owner. Now, the employers declined this request and said no. And she actually resigned and claimed constructive dismissal, an unfair dismissal. And this actually won at tribunal. They said it was an unreasonable. They should have actually considered it and allowed the previous practice owner to be there, as there was no evidence they would be able to influence the hearing. So just really consider, and again, get advice at this stage if you are asked first to think about somebody else attending. So the disciplinary hearing itself, now we know when we speak to members, this is probably the most daunting part, especially if you've never conducted one before or are scared of what you can and can't say in this hearing. And again, it comes back to making sure your investigation is spot on. So conducting a disciplinary hearing, the setup would be normally yourself, and we know at this stage it's quite often the practice manager or the owner that would be conducting this. And you would have a note taker. So the note taker does not participate in the hearing at all. They are there predominantly just to take notes, and you need to make sure that they understand it is confidential and not to talk about any of the contents of the hearing with anyone else. You'd also obviously have the employee there and their whoever they wanted to have accompanied that you've considered. So there's normally 4 that would be in that hearing. And the idea of the hearing is that you would state first the allegations and why you were there. And then you would go through the investigation notes and all the physical evidence. But the most important part to make this a fair hearing is to allow the employee to put their side across and be able to fully state their case. So you need to go through things, ask them questions based on the investigation. You can't take into account any new evidence. It has to be what you've already got there. If the employee presents new evidence, then this is where we actually advise that you need to adjourn the hearing and you'd have to go back to the investigation stage. To continue or to ignore the evidence would put you at risk of that unfair dismissal claim. When I'd say another thing that does come up quite often on the helpline is that they ask whether they can use a recording device for their disciplinary hearing. Now, if you are doing this, you need to be very transparent, and it needs to be agreed by both parties that you are doing this as well. So have excellent records of notes in this hearing as well. And if your employee has declined their right to be accompanied, make sure this is clearly stated in the notes that they were given this right and didn't take it up. So that will cover you there. So outcome of the hearing. So a common myth again is you don't have to give the outcome of your decision at the end of the hearing. Actually, it's better to say to them, we will write to you with our decision. We will consider everything first, and then we will write to you of what our decision and outcome is. And then following that would be the right to appeal. That must be clear. And that would be the date that you give it to them, normally 5 days, and they have to state the grounds for their appeal. And you need to make it very clear who that appeal is to. If it is a gross misconduct situation, I strongly advise that you have another level and some external support there to do the different levels of the hearing. Otherwise, it can be seen as unfair. So we're coming into I don't want it to be all doom and gloom with the unfair dismissal claims, because it doesn't mean if you don't follow the ACAS Code of Practice all the way through that you're automatically going to end up with a claim on your desk. However, there's the risk, and it's about mitigating that risk. So unfortunately, failure to follow a fair dismissal process can result in an additional 25% on top of any award that's made for unfair dismissal claims, which you can see is quite a hefty amount there, just been increased actually to 83,000. So that's not following any stage of the ACAS Code of Practice. They add on the 25%. On the upside, they also deduct from any compensation of the employee 25% if the employee has been unreasonable and not followed the code as well. So hopefully that is there to try and offset. Now, employees who have 2 years of continuous service are the ones that are eligible to make an unfair dismissal claim. However, and we do receive this a lot on the helpline, that they think that we're able to not follow a fair dismissal process if they have attendance, a service lower than that. But they are protected by so much, other legislation in terms of wrongful dismissal, discrimination claims. So it's always better to follow a fair dismissal process. However, you can condense it. So for probationary periods, we have a condensed process there. But again, get advice at each stage so you're not making any mistakes there. Now, for a fair dismissal claim, from the date of termination, they have 3 months less than 1 day to be able to make a claim for unfair dismissal. And that leads into the ACAS early conciliation. Now, this is introduced by the government and ACAS to try and reduce the amount of tribunal claims that were, ending up in tribunals. And legally you have to engage with the ACAS conciliation. Otherwise, this is going to go heavily against you at tribunal if you refuse to do this. The ex-employee has to log the claim. It does pause the process. So where it goes from you having 3 months, it gives you an extra month backwards and forwards to try and agree a settlement. And that tends to be what happens here. So although the extreme, a lot do go to tribunals, more than often than not, you end up in a settlement situation. Again, we want to avoid getting to that stage, which is why I go back to making sure you seek that external HR support at each stage of the situation, so you don't end up making those common mistakes. I would say the top 5, and I was talking to the rest of the total HR team, we were going through what are common issues that come up. I say the number 1 on our helpline is that having the same person conduct the investigation and chair the hearing and also hold the appeal. And again, we know how difficult it is in a smaller business or a small practice of not having all those different levels. I'd say that's where it comes back to making sure you do a thorough investigation is so important. But gross misconduct, please get support there and have some external in to help you. I'd say the second one we do receive is where warnings have been issued to team members in a letter format, and just we had a member saying, well, we've given them a written warning, they're on a final written warning, but no disciplinary process has been followed, there's been no investigation, they've just been handed a letter to say that's on your file now. So that would be automatically unfair. I say that a third one that comes up regularly is not allowing them to be accompanied at the hearing or rushing the hearing. This is another one that we have the incident in the morning, the suspicion, the investigation's done, and they're asking if they can hold the disciplinary in the afternoon. Even though there's no legal, it doesn't state how much notice you need to give of a disciplinary hearing, really it should be at least 24 hours. But going back to your disciplinary procedure, you need to go by that. So if you state 3 days, that's what you should be giving. If it's gross misconduct, you need to give even longer. I would say at least a week to help them prepare. Otherwise, it's seen as automatically unfair. So I don't want to go too doom and gloom on that. However, we know that since he abolished the tribunal fees, we've seen a 90% increase, which is again why I think we've seen an increase on the helpline of members asking for help and support in this area. So just a summary of do's, so just a recap of what we suggested that you make sure you do is, again, I can't stress this enough, is to seek expert HR advice at all of the stages. You've seen the risks that are involved with getting it wrong, and they're all different depending on what the situation is. Train and communicate your standards. So going back, prevention, if you are in recruiting the right people, follow your due diligence there, do your checks, your pre-employment checks, get the right people in your practice, will reduce the risk of ending up in these situations. Make sure they're fully aware of their job description, the standards, the policies and procedures, and what you expect from them as well. And that you're recording those informal chats as you go along to try and help them improve and support them. Make sure you review your disciplinary procedure, that you have our latest one that we have on iComply as well, and that you familiarise yourself with the ACAS Code of Practice. It's so important. Those disciplinary procedures, you should be signed copies of those in your staff files, and those of you using our staff file checklist will see that's on there as well. Full investigations before any hearing, so not going straight to issuing a warning, making sure you're doing your fact finding first and establishing the facts, making sure before jumping the gun. Keep full notes of the hearing as well, making sure they're in place, because that's what tribunals will look at, unfortunately. And also consider all of the role of the companion requests that come in. Now, unfortunately, tribunals will not look at whether the employee has committed the act, or, for example, even if the employee has said, yes, I did steal, this is exactly what I did, I've committed the act, they will look to see if you followed the process. If you've not suspended them or not allowed them a fair hearing, that's what they will judge you on, and that's what they make the call on. So some of the don'ts, we say rush in too quickly, try to do things that you think, I need to take action now. And where we see problems with this is suspending someone who, where there is no foundation to it, and the damage that can do ongoing, not just the risk financially of a claim, but the relationship as well. So it's getting a balance of not delaying the action, but not rushing it either. And again, that's where seeking advice as well of what action you need to take. That ties in with not, taking careful consideration to when you suspend an employee, issue any warnings without following the process, or have the same person deal with each stage of the disciplinary. Again, we know how difficult that can be. Preempt the outcome of a disciplinary. Now, we had a situation this week, actually, one of my colleagues who, fortunately, the member called us as they adjourned the disciplinary hearing and was asking whether it was okay to give the decision there and then, as he had actually prepared the letter before the hearing, which indicated they were on a final written warning, and the letter was predated. And so clearly, fortunately, he called us and we'll be able to say, no, don't do that, because automatically that shows that there was no point to having the hearing, as the decision, the outcome had already been determined. So be very careful in making that decision. Try not to jump straight to gross misconduct when it's a first misdemeanor, depending on what the situation is. Obviously, if there's physical violence or anything like that, but you still need to do an investigation. Or dismiss without giving the right to appeal. So it brings me back to try not to go it along alone and do this. If your gut feeling is telling you that something's not quite right, then please seek advice. So this brings us into, so although I always say your employees are obviously your biggest asset, but they're also your biggest risk. And this is about outsourcing your risk, and this is why we've put together this Total HR Employment Law Service. It's something we found from our members and the difficulties they come up against in the practice that we really needed to help them with. And I'd say the most rewarding part of our job, and I speak for the rest of the HR team here, is knowing that we have helped a member and save them potentially from making quite innocently an error, but we know what that could potentially lead them into. So this service, we provide you with all your full HR documentation, all your contracts and setup, which is proving to be very popular. And that's not just for your employees, but also for your self-employed. And the contracts also set out the standards and the code of practice that you want them to work to, which is what you need to help manage them and avoid these pitfalls of disciplinaries. We also have your HR documentation, unlimited access to a code HR advisor, which we're finding very, very, I'd say popular in terms of with our total members. And I can see we have some with us today as well, because you know, if you look at how long a disciplinary takes to resolve, looking at 10 hours of your time, that, you know, that support from a HR advisor talking you through that will help mitigate that risk as well. We also have an application that will help you, which manages all your time and manages all your holidays and absence and sickness. I know a few people have been going through sickness issues today. I've seen that on the chain. And we also offer, there's part of that package is the insurance as well, which will help you if you are in the unfortunate situation of an employee trying to make a claim. So I think the biggest pulling point, we mentioned some of the template letters that we have there for our members and using if you're inviting into a disciplinary or a decision or an outcome. We have the templates, but what we will do with Total HR is actually write those and prepare those for you to the situation you're in. So I think that's a really good selling point there in terms of you know, that support. But what I would say, obviously try and get some external HR support. Ideally, it would be good for us because we are dental as well and be able to support you there. But either way, you need to think about that risk. Okay, so going back, I know those of you, we have over 100 HR templates on our iComply system and use lots of policies and templates for you relating to disciplinary and grievance here as well. So please have a look at all of these. There's some top ones there I draw your attention to is the disciplinary hearing record, the investigation record, very, very useful when you're in this situation. Okay, now those of you who may have already looked on our website, we have, I mentioned earlier, this is the very first of our HR webinars. We're going to be doing a series of 10 altogether, and we're aiming to do these every couple of weeks, and they will stop just before Christmas. Can't believe I'm talking about Christmas already, before we move into February, and they'll start up again. But we tailor them to be topics that people want to know and learn about as well. So my colleague Hannah will be doing the next one on handling grievances and unacceptable behaviour, which is a big topic in the practices at the moment that we're finding. And we're very excited. We've also got our HR and employment law seminar coming up on the 9th of November. I can see some of the delegates' names already that have popped up that are joining us that day. And we have Tracy Stewart. Those of you that have come to our practice manager conferences may be familiar with her. So that'll be a very full-on day of lots of HR and employment law, but it would also be interactive and some mock disciplinaries, difficult conversations. We're throwing everything in there. And we have our compliance update day coming up as well on the 23rd of November. So please have a look on our code website if you're interested in any of those, and you can book.